Good evening, everyone. Am I audible? Am I audible to all of you? Okay, just give me a second. So, welcome to the final session of Vidhigyata Civil Drafting Internship program. It has been enriching journey for all participants, and we are delighted to conclude it with a special session. It is my privilege to welcome our esteemed guest for today's session, Advocate Manas Mishra sir. Before we begin, I am pleased to announce that Vidhigyata will soon open registration for the next drafting internship for the month of June. We request all the participants to share this opportunity with their friends and peers who may benefit from it. Without further any delay, I warmly invite Advocate Manas Mishra sir to take over the session. Thank you, everyone. Thank you so much. So you can.
Thank you so much, of course, for this introduction, and thank you so much, team Vidhigyata and all the associated members. And thank you so much, participants, for giving me this opportunity to have a last session, the fourth session with me. I am sharing the PPT. Hope the PPT is visible. So, today we are going to discuss another important drafting in civil procedure. Uh, but before the drafting part, I would like to have some elaboration on the theoretical part of the topic that I have been given is divorce petition and divorce in Hindu marriage act. So the lecture is not merely about the memorizing sections associated with the divorce in the Hindu marriage act, but it's about understanding how law intervenes when deeply with the personal institutions like marriage and its breakdown. So let's begin with the concept of divorce in India. So divorce is a legal dissolution of valid marriage by a decree of competent court, meaning thereby that marriage which was lawfully formed is formally as well as officially has been brought to an end through a court's judgment. So it can be inferred from the definition that it is not merely the separation of two between the spouses, but a legal termination of something which has been recognized by law earlier, and now situation has taken place where the breakdown of marriage is being taken place, and it is also being recognized by the law. So once a decree of divorce is granted, it puts an end to the marital status of the parties, and they are no longer considered as a husband and wife in the eye of law. It also releases them from all the marital obligations such as duty to live together, maintain each other, and remain faithful to each other. And furthermore, divorce gives both the parties the legal right to remarry, which would otherwise be prohibited during the subsistence of the valid marriage, the period between while going through a valid marriage. Under Hindu law, a marriage was originally regarded as a sacrament, a sacred or sanskar that we say. It has some it has some sanctity, uh, signifying a sacred lifelong union with religious as well as spiritual significance, not merely a social contract as we see under the Muslim law. And it was considered as an indissoluble. with the emphasis on duties, rights, rituals, permanence. However, after the enactment of Hindu Marriage Act 1955, the nature of marriage has, under Hindu law, acquired some contractual character. So the Act introduced provisions like divorce, judicial separations, restitution of conjugal rights, and conditions for marriage under Section 5 of the Act as well, which reflects some elements of agreements, rights, and obligation between the parties. Thus, we can say that modern Hindu marriage is a blend of sacramental and contractual elements, retaining its religious essence while incorporating legal flexibility. I hope you guys have understood this well. So, this is the status as of now till 2026, the status of divorce law under the Hindu Marriage Act. So far as historical background of the divorce in India, specifically Hindu Marriage Act under Hindu Marriage Act is concerned. So before the situation before 1955, before enactment of the Hindu Marriage Act was that there was no uniform divorce law for Hindus in India, and some customs were permitted within a permissible limits for separation. And women had minimal legal remedies, and marriage was treated as indissoluble. But the situation changed after the enactment enforcement of the Act 1955 based Act, Hindu Marriage Act, and Section 13 was introduced with structured ground for divorce in India with reference to Hindu marriage. Both husbands and wife were given certain rights. Courts were empowered to evaluate evidences and judicial interpretations. Since 1955 till today, there has been certain number of judicial pronouncement with reference to specific words that has been used under Section 13 of the Hindu Marriage Act. If we take an example, for example, cruelty. So cruelty has got so many interpretations from time to time. From Russell versus Russell, this was the first case where the term cruelty was defined, and the court held that cruelty is a conduct of such character as to have caused danger to life, limb, or health, bodily or mentally, or give rise to reasonable apprehension of such conduct. Then Dastane versus Dastane, Sobha Rani versus Madhukar Reddy, Suman Kapoor versus Sudhir Kapoor, 2009. So from judicial pronouncement, we have seen that there has been change, shift from one terminology to another terminology, and specific word has been granted specific meaning from time to time. As we see that law is dynamic in nature. So from time to time, there is a requirement of interpretation of terms used under the Institute of Law. So this is the very great example of the Hindu Marriage Act 1955, and this provision are the great examples of law changing the society and society changing the law. So this has been a historical background of the act. So we can say that the codification has democratized the matrimonial belief, and family law of India has moved from blind preservation of marriage to conditional preservation, subject to justice, liberty, fairness, dignity, and so many terms that we encounter under the Constitution of India. So far as grounds of the divorce is concerned, under Section 13 of the Hindu Marriage Act is that first is the adultery, cruelty, desertion, conversion, unsoundness of mind, virulent and incurable leprosy. This has been omitted by the Personal Law Amendment Act 2019, and venerable diseases, renunciation of word, and the person not heard alive for 7 years. So one by one, we will. I would like to have some deliberation on each of the grounds in a very brief manner. So under Section 13, subsection 1, clause I, subclause A, which provides that the petition for divorce may be presented by either party if after the solemnization of marriage, the other party has treated the petitioner with cruelty. And the term cruelty is not defined under the Act. The Hindu Marriage Act does not define the term cruelty. However, there can be various forms of cruelty, for example, physical cruelty, mental cruelty, and so many things that I have already said that from case to case, Supreme Court of India has had given so many judicial pronouncement to broaden the term cruelty. So a number of case laws are there. Then we have a desertion, another ground. Then we have adultery, the another ground, and the first ground. So, section 13, clause 1, subclause I provides that the petition for divorce may be presented by either party if after the solemnization of marriage, the other party had voluntary sexual intercourse with any person other than his or her spouses. So far as the contemporary relevance or contemporary things trend is concerned, so in Joseph Sine versus Union of India, adultery has been declared unconstitutional, but the court has expressly held that it will remain a ground for divorce in matrimonial cases. Then we have a desertion. For a time period of 2 years, there has been the spouse has deserted, the another spouse has deserted the petitioner for a continuous period of not less than 2 years, immediately preceding the presentation of the petition before the court of law. And the same as the cruelty, the term desertion has also not been defined in the law. So far as essential or desertion is concerned, so there has to be a factum of separation. There must be intention to bring cohabitation to an end that we know as animus diserendi, and such conduct must be without any reasonable cause, and it must be without the consent of the other party. So far as the landmark judgments in with reference to desertion is concerned, so there is a Savitri Pandey versus Premchand Pandey, in which Supreme Court held that the party seeking divorce on the ground of desertion is required to show that he or she is not taking advantage of his or her own wrongs. So there can be two kind of desertion, actual as well as constructive. Then we have another ground, conversion. So Hindu Marriage Act provides that the petition for divorce may be presented by either party if the other has ceased to be Hindu by conversion to another religion. So conversion does not itself result in divorce. The ground of divorce on the basis of conversion will be available to the converting spouse as it would amount to taking advantage of his own wrong. Next, we have unsoundness of mind. For example, the other party has been suffering from suffering incurably of unsoundness of mind, or has been suffering continuously or continuously some mental disorder of such kind, and to such extent that the petitioner cannot reasonably be expected to live with the respondent. So this has been a ground of divorce under the Hindu Marriage Act. Then we have virulent and incurable leprosy. So this has been removed by the Personal Law Amendment Act 2019. Next we have venerable disease. So venerable disease means that any disease which is communicable in from one person to another person. So it is also a ground for the divorce under the Hindu Marriage Act. Then we have a renunciation of word. The other spouse has renounced the word, and the petitioner can file a divorce petition on the ground of renunciation of word. So what is so far as the status of renunciation under the law is concerned, so it amounts to civil death, and therefore it is also included as a ground for the divorce under the Hindu law. Next, we have presumption of death. For example, a person who has not been seen for 7 years or more, then that person is considered as a that he has. It is presumed that he has met some kind of unnatural things. So cruelty and desertion I have discussed in detail. Next, there are certain grounds that are available only to wives. For example, the husband has found to be guilty of rape, sodomy, and bestiality. So it is a ground available to wife that she can file a divorce petition before the court and get himself out of this marital relationship. Get herself out of this marital relationship. Next, no resumption of cohabitation after degree or order of maintenance. So, under the section 13, clause 2, subclause 3 provides that the wife may also present a petition for a dissolution of her marriage on the ground that there has been no resumption of cohabitation after a decree of maintenance has been passed under section 18 of the Hindu Adoption and Maintenance Act and section 125 of the Code of Civil Procedure, and as of now, section 144 of the BNSS. Then next we have option of poverty also, which provides that wife may present a petition for devolution of her marriage on the ground that her marriage was solemnized before the attainment of the age of 15 years and after attaining that age, and she has repudiated the marriage after attaining that age but before attaining the age of 18 years. So this is also a ground available to wives to get out of such relationships. So these things I will be discussing. The structure of divorce petition is concerned, I will be discussing in draft part. So we are moving towards the draft of the divorce petition. Hope the slide was visible. Hello everyone. Okay. So this draft has been prepared by the team Vidhigyata. So the sample, the draft of this divorce petition, the issue of this divorce petition is that the just a second. The marriage between Anjali, who is 27-year-old, and Rohit, 30-year-old, was solemnized on January 19, 2025 in Delhi, according to Hindu rites and ceremonies. Before the marriage, Anjali resided in Punjabi Bagh, while Rohit lived in Rajouri Garden. The marriage was officially registered with the Registrar of Marriage, and a certified copy of the extract from Hindu Marriage Register was maintained as a proof. After moving into the matrimonial home at Rajouri Garden, Anjali discovered that Rohit was jobless and entirely dependent on his parents and his financial needs. Only three Only 3 months after the wedding, Rohit demanded that Anjali to bring 12 lakh rupees from her parents, specifically stating that he wanted the money to book a new car for himself. When she refused to meet the demand, the situation turned into a companion of torture, pestering, and harassment that lasted for 7 months. Something that need to be circled here only. So there was an amount of 12 lakh rupees, then 7 months, for 7 months he has been tortured, and the physical and mental toll of this treatment was so severe that he eventually required hospitalization. Upon her discharge from the hospital, Anjali left the matrimonial home to seek refuge with her parents in Punjabi Bagh. Despite her departure, no effort was made by Rohit or his family to bring her back or reconcile, while Anjali later returned to the matrimonial house with her brother to collect her jewelry and personal belongings. Both were insulted and she was forcibly prevented from taking her position back. Here it is also it's talking about the Stridhan thing. So those who have studied Hindu law in detail, they must be aware of the term Stridhan. So we are coming to the draft part of this petition. Yes. So far as the structure of the divorce petition is concerned, so a divorce petition consists of 6 to 7 very important things that it must have. First is the jurisdiction clause, or we say the title and the code in which the territorial jurisdiction lies. Next is the cause title, then what is the provision under which the petition has been filed, then facts in a numbered paragraph we will have to mention, then the grounds of divorce on which the divorce can be sought, and then prayer clause and verification clause has to be added for successful submission and increase the chances of getting it accepted by the court. So first and foremost thing, so far in so many drafts we have seen that we will have to mention the jurisdiction clause of the court. So here it is written that in the family code of Delhi. So this has to be written at the top of the petition while drafting, and the Hindu Marriage Act petition number has to be mentioned here, and the date in the year in which the petition is being presented before the court. Next we have a cause title. So cause title ensures that the case is correctly registered and it has been served as well as recorded, and it contains the name of the parties, age of the parties, and address of the parties. As we can see here, it is written that this is the way to write in the matter of. In whose matter? In the matter of Srimati Anjali Rohit Yadav, who is wife of Rohit Jadhav, and who is aged about 27 years and still resides at this place. So, versus Mr. Sri Rohit Jadhav, son of Mukesh Jadhav, who is aged about 30 years and residing at this place. So far as this clause is concerned, it's our cause title. Here I am writing. ये हमारा cause title. Next important thing that I have already told, that in which section, in what provision is being invoked for filing the divorce petition before the court of law, that has to be written next, and that is the section as written here, petition under section 13 subsection 1 clause I subclause A of the Hindu Marriage Act 1955 for the dissolution of marriage on the ground of cruelty. The ground has also been mentioned here. So, what is the significance of this, of writing this provision, is that it creates a legal basis, and in our case is the cruelty as well as provided under section 13 clause 1 subclause IA, the under which the petition is being presented before the court of law. Next, what we are supposed to write in the divorce petition while drafting the same is that it is written here, the opening line or opening statement with the most respectfully so with, which signifies a formal submission is being made before the court of law. So, it is written here. So, I am reading one by one each paragraph that has been written here as a fact of the cases. The first one is that the petitioner and respondent were lawfully married on 19th January 2025 in Delhi according to Hindu rites and ceremonies. A copy of marriage certificate is annexed herewith and marked as Annexure A. So this first para talks about the marriage detail, and marriage details includes the date on which the marriage has taken place, the place where the marriage has taken place, and it establishes as the existence of valid marriage as a proof of valid marriage. So it must be mentioned here. So in paragraph 1, our work is done, that the marriage detail has been mentioned here. Next paragraph we will have, we are supposed to write the religion of the parties. So according to the facts that we have so far seen, is that the parties are Hindu by religion and governed by the provisions of the Hindu Marriage Act. So first, this is the religion thing. We have to mention the religion of the parties. Next is their matrimonial home. That after the marriage, the parties resided together as husband and wife at Block J, Rajouri Garden, and matrimonial home was established in Delhi. So matrimonial home, the detail of matrimonial home is written, supposed to be written, and then fourth clause, if we talk about, so from the fourth clause to clause number, let me see, from clause number to 11, we are going to talk about the specific facts of the case related to this matter that has been taken here and that has been presented before the court. So first one is that the subsequent to the solemnization of marriage, the petitioner discovered the fact that respondent was unemployed and entirely dependent upon his parents, and that such material fact had been concealed from the petitioner before the marriage. So what the situation here is that which creates a legal basis or a specific or very certain ground for getting the divorce petition being accepted here is that there has been a concealment of fact on behalf of the defendant. So this has to be written. Next paragraph that we have is that the continuous unlawful demand of 12 lakh, there has been a demand of 12 lakh maybe in the form of dowry or something. So there has been a demand of 12 lakh rupees by the respondent, and which and on the situation that the demand has not been met, the she has been harassed, and there has been physical as well as mental cruelty that we have seen as a essential as a further classification of cruelty under section 13 upon refusal of petitioner to fulfill said demand, as I have said, caused grave mental agony and apprehension of her safety. So this creates a very strong ground that there has been a cruelty on the part of the respondent. Then we have sixth number, that the conduct of the respondent in demanding money from the petitioner's parental home for purchasing a car amount to dowry demand and constitute cruelty within section 13 clause 1, 13 subsection 1 clause I subclause A of the Hindu Marriage Act. So there has been a dowry demand as specifically written here, and here at this point the fact is being connected with the law that is prescribed under the Hindu Marriage Act 1955. The point number 7 is that due to the repeated acts of harassment, humiliation, and physical assault, the petitioner's health was deteriorated severely, and she was compelled to undergo medical treatment and hospitalization. And further, the copies of medical records are annexed herewith. So till this paragraph and further more paragraphs, we can see that how the facts are being interlinked, are being connected here to create a very strong ground for seeking the divorce before the court of law. So this has been another fact that there has been some certain kind of medical harm and wife has been hospitalized, which creates a strong evidence for serious cruelty. Then we have paragraph number 8, that after being discharged from the hospital, the petitioner was constrained to leave the matrimonial home and take shelter at her parental residence for her safety and well-being. In order to secure the safety and security of the petitioner, she has moved from her matrimonial home to parental home in order to be in good situation, that no further harm or cruelty can take place from the part of the respondent. As we have seen that in the expansion of the term cruelty, as defined under Russell versus Russell, that there may be threat to life, limb, and so many things. So this is being demonstrated here, that there was a threat to her life as well as limb, and therefore she has taken shelter at at her parental home, neglecting the matrimonial house. Next, we have paragraph number 9, that despite the petitioner's departure, the respondent made no sincere effort to resume cohabitation or to ensure her welfare, thereby demonstrating neglect and indifference toward a matrimonial relationship. So there has been no serious effort that has been taken by the respondent to make the situation good or to settle down the issues between them. So this has to be mentioned, which shows that there has been a continuous cruelty being taken place by them on petitioner, which creates a very strong basis for seeking divorce. Then earlier, as I have said, the Stridhan thing, that when the petitioner visited the matrimonial home along her brother to collect her Stridhan, the right of the nuptial women, jewelry, and certain personal belongings. So what the situation was, that she was insulted and threatened and forcibly prevented from taking possession of her article, which is violation of her property rights. So this is another ground for a strong basis. Then, from para number 11, it can be inferred that the acts and the conduct of the respondent have caused the petitioner several severe mental cruelty, certain emotional trauma, and loss of trust, making it impossible for her to continue marital relationship. As we have seen, as an element of the divorce, that it has been very difficult. The situation has become very difficult for the petitioner to be with the respondent as well as the family of the husband. So for the reason of this mental cruelty, emotional trauma, and loss of trust between them and the families involved, so it makes impossible for the petitioner to live with them and continue her marital life. Paragraph 12 speaks that there is no collusion between the parties in filing the present petition. So far as the interpretation of this clause is concerned, the term collusion here refers to a fraudulent agreement between parties to misuse the judicial process, the process being taken here. This clause means that the petitioner and respondent are not secretly cooperating or conspiring to obtain the divorce decree by misleading the court. This is the interpretation of this clause, and very important thing that we have to mention in any divorce petition. Now we are done with the facts of the case till paragraph number 11. Now we are talking about some general as well as specific things that has to be mentioned in a divorce petition. And next paragraph 13 is that the cause of action arose between the jurisdiction of the honorable court, that we have already mentioned at the as a cause title, the jurisdiction clause, and here we are also mentioning and telling the court that the territorial jurisdiction of this court is lie here in order to go with the case. So this territorial jurisdiction has to be mentioned here. And further, paragraph 14 talks that no other petition regarding the present marriage has been filed or is pending before any competent court. So from this paragraph number 14, it can be inferred that the matter is not sub judice before any court of law. Then paragraph number 15 and last paragraph is that the petitioner, being woman, is being exempted from paying court fees under the Court Fees Act. So under the Court Fees Act, the Court Fees Act exempt a woman from getting the payment court fee being paid off. So this has to be mentioned. So we are done with the fact of the cases, the general thing, the specific thing that has to be mentioned in the divorce petition following the opening statement. Now, there are two most important things that has to be attached here with is the prayer clause and verification. So far as the term prayer clause or the interpretation of prayer clause is concerned, so prayer clause is the final and most crucial part of any legal petition where the petitioner clearly specified the reliefs sought from the court. It tells the court what exactly the petitioner wants from the court. So prayer clause is our prayer clause, like in our case, it contains a specific request such as grant of divorce. From the para number 1, we can infer that the pass a decree of divorce under section 13 subclause subsection 1, subclause I, and clause I, subclause B of Hindu Marriage Act 1955, thereby dissolving the marriage between the petitioner and respondent, solemnized on this date. So here the petitioner is pleading for the grant of the divorce. Next is the direct the respondent to return the petitioner's stridhan, jewelry, and all personal belongings forthwith. So here it is being requested that to return the proper stridhan, which is the property right of the any marital women. Third is the grant of interim maintenance relief in favor of petitioner during the pendency of this petitioner under section 24 of the Hindu Marriage Act of 1955, as this honorable court may deem fit and proper. So here it is talking about the maintenance, interim maintenance of the petitioner by the respondent, and award the cost of the present petition in favor of the petitioner. Whatsoever cost has been incurred by on part of the petitioner, that has to be met by the respondent. That has been brought, that has been spent in bringing this suit before the court. Last is the pass such order and further orders as this court deem fit and proper in the interest of justice. So finally, she is seeking divorce from the court and requesting the court to grant her divorce so that she can continue her life peacefully. Next, what another thing that we have to attach here is the verification. So as written here, I, Anjali Rohit Jadhav, the petitioner above named, do hereby verify that the contents of this petition from para number 1 to 15 are true to my knowledge, and those from para number 1 to 15 are based on legal advice which I believe to be correct, and it has been verified at Delhi. The place has to be mentioned and the date, the 20th February of 2026, and it has to be signed by the petitioner as well as the advocate of the petitioner. From in prayer clause also as well as verification. So it is a declaration that whatever is stated in the petition is true to the knowledge of the petitioner, and it is based on the legal advice that she has sought from the concerned advocate of her. So, just a second. The drafting part here it is done. Okay. Just yes. Push. 1 second. Let me just. Yes. So here the session is being the final session of this civil drafting course has been concluded here. And so far as the divorce petition is concerned, so it can be said that it is not a formality. It requires proper understanding of law. There must be proper drafting skill that has to be considered. There has not to be any kind of spelling mistake, grammar mistake that can make the impression of the council and impression of the divorce petition so bad before the court and before the judge. So it has to be strategically readed, and there must be some awareness of judicial trends, judicial pronouncement on which the ground. For example, in our case, the ground has been the cruelty. So there must be certain judicial pronouncement that must be known to the council that is presenting before the court. For example, some famous case laws like Shobarani versus Madhukar Reddy, in which it was held that the demand for dowry also constitutes a cruelty, as we have seen that 12 lakh rupees has been demanded from the respondent by the petitioner. And certain cases like Suman Kapoor versus Sudhir Kapoor, V Bhagat versus D Bhagat, and so many cases are which has to be well certain, well known to the knowledge of the council. uh, then we have a well drafted, it can be said that a well drafted petition increases the chance of success, and the petitioner can withdraw the marriage, can get out of this arranged kind of marriage and continue her peaceful life, dependent life, and or go to a and start with another life that she is comfortable. So I am concluding the session. Thank you so much, participants, for listening me. Thank you so much, Team Vidhigyata and Ashutosh specifically, and Soumya as well, for giving me this opportunity to deliver the 4 sessions uh, in the continuance of this program, this civil drafting course. Thank you so much. Thank you. Okay, thank you, Ashutosh.